Subcommittee are hereby advised of their duty under the State Ethics and Government Act to avoid any conflicts of interest or the appearance of any conflict, and are instructed to refrain from participating in any matter coming before this committee with respect to which there's a conflict of interest or an appearance of conflict. I'm George Jenkins. I'm an attorney in private practice in Kinston, in the eastern part of the state. The other members of the committee are Chief Judge Linda McGee, who is, I believe, sitting in Raleigh, but who has some significant contact with the western part of the state and with the Outer Banks. So we're glad to have her with us. Professor Jim Drennan is with us. He is a retired professor from the School of Government. We're honored to have you as part of our group. Dorothy Hairston Mitchell is the assistant clinical professor of law at North Carolina Central University School of Law, and she is also a member of the Council of the North Carolina State Bar. So we are honored that you are with us. Then the others that are with us, Deborah Holland, Alice Mine, and Peter Bolak, are with the North Carolina State Bar, and at least in conducting this meeting, I count on them to keep me straight. That being said, Peter, may I turn the meeting over to you?
Sure. Just a couple of quick housekeeping notes as it relates to the Zoom meeting. We are live streaming this meeting. It's on YouTube, on the State Bar's YouTube channel. So just keep that in mind as it relates to our conversations. And if what we are going to do in order to keep the meeting the most efficient as possible on Zoom is we're going to have everyone muted other than the person on the who has the floor. If you want to get the attention of the group to make a comment or ask a question, the best way to do it is to use the raise your hand function in Zoom. The way to find that is if you click the button at the bottom of your screen that says participants, the participants list will come up. At the bottom of that screen, there's some buttons that say yes, no, raise your hand, go slower, go faster. And so clicking the raise your hand button will allow me to know that you'd like to make a comment. If that's not working for you, if that you're having trouble finding it, this works too. So I'll do my best to try to see that. Or if that's not working, just go ahead and unmute yourself and interrupt us. So that's the best way to handle this if we can, to try to make the meetings the most efficient as possible. I think that's all we got for housekeeping stuff. I don't imagine that I don't think we're going to be doing any voting today, so we won't need to go over kind of how we're going to do the voting process at this time. George.
Very well. All right. Mr. Williams is with us today. James Williams is the chair of North Carolina CRED. That is the Commission on Racial and Ethnic Disparity in the Criminal Justice System. Did I say that right, Mr. Williams?
You did fine.
Thank you. We're looking forward to a presentation from him relevant to the need for racial diversity, continuing legal education for members of the bar. So, Mr. Williams, with your permission, I'll turn it over to you.
Thank you. I appreciate the opportunity to, I don't know, presentation might be too formal a term for what I'm about to do, but certainly to present or discuss with you what I, and I think members of my commission view as a critical need related to justice in this state and the need for this bar to take some action. If you might indulge me, I think I want to give a little bit of a historical perspective. I think, history is reflected in everything that we do. We don't always acknowledge that. And I think sometimes we do that to our disservice because quite often the issues that we are engaged in, there is that shadow, that reflection of historical actions that are current and present. And so I want to start with 1951, April 26, 1951, which actually is my date of birth. And I do that for several reasons, but one is because that same month, I believe in April of 1951, the Fourth Circuit of the Federal Circuit decided Carmichael versus Mckissick, which basically said to the University of North Carolina that it could no longer continue to use race to deny, Black applicants admission to its law school, because there was no separate but equal law school in the state of North Carolina. And then I want to take us back 50 years before that, 1901, and the US Congress. George H. White, who was a Black attorney, was the last remaining African American in Congress at that time. And in 1901, he gave what we refer to as his farewell speech. And that period was what historians refer to as the nadir period for African Americans, particularly in the South. And there were several things going on. I won't get into all the details, but racial terror, certainly. The fact that the North Carolina legislature had just passed a constitutional amendment, basically eradicating the ballot for Black people in the state. And George H. White gave his speech, which is a very famous speech, and he shortly left the state of North Carolina because of the very climate that was ongoing. I mentioned that year also because 1901 was the year that a Black lawyer by the name of Pete Bell was licensed to practice law in the state of North Carolina. And I think about that in terms of what it was like for this newly licensed Black lawyer to practice his craft in the climate that I just described. And he ended up in my hometown of Plymouth, North Carolina. I did not get to know, and we all called him Lawyer Bell, until he was an old man, and certainly an elderly gentleman. And I was probably in my pre-teens. But we are told that Lawyer Bell was not allowed to practice law as white lawyers, who had the same or lesser skills than he had. There were certain things that he could not do, including litigating matters in the courts of the state of North Carolina. He was relegated to doing things like wills and deeds and, things like that, mainly for the Black community. On occasion, he would be hired by white lawyers to write briefs for matters that were appealed to our appellate courts because he was an excellent legal scholar and he did an excellent job in those briefs. Well, here again, I'm going to circle back to 1951 because it was in 1951 that Lawyer Bell's son, Charles Bell, becomes licensed to practice law in the state of North Carolina. And Charles Bell ultimately moves to Charlotte And there in Charlotte, he was one of the founders of the John Leary Bar. Now, the John Leary Bar was and is a Black bar. And one of the reasons that that bar was created was because Black attorneys were not allowed to join the predominant or the white bars at that time. And I mean, looking back, it was, sometime later that the North Carolina Bar Association, for instance, allowed Black lawyers to attend, I believe I don't remember the exact date, I think in the early 70s or late 60s, mainly over a threat by Duke Law School to withdraw its affiliation with the Bar Association because they had denied two of the graduates, Black graduates of Duke Law School, to join. And so, I think about those things in terms of the current moment, but I also think about 1951 for another reason, because 3 years later, 1954, Brown versus Board of Education was decided. And of course, I'm 3 years old at that time. And a year later, we have Brown 2 in 1955. And I think this year marks the 65-year anniversary of Brown 2. But there are a couple of things, but one thing that happened in 1955 and 1956 that is really relevant to this conversation. Because the state bar held public hearings. And I believe for the first time it's ever been done. Whether it's been done since that time, I don't know. But the sole purpose of those hearings was for the bar to recommend to the state of North Carolina, I guess to the legislature and to the people of the state of North Carolina, what course it should follow regarding Brown versus Board of Education. Basically, do we follow the law of the land as determined by the Supreme Court of the land, or do we disobey? And a number of the esteemed members of the bar from across the state appeared in Raleigh over those 2 years to give their opinion. And they were all white and they were all male. And almost to a person, they took the position that Brown versus Board of Education would wreak havoc in the state of North Carolina and do harm. And there are a number of reasons they gave for that we don't need to get into, but I think it's fairly apparent to anyone who's on this call. There was one person who stood out in particular, and his name is Irving Carlisle. And I want to come back to him in a minute because he took a different approach. So at that moment in our state's history, when our bar had the opportunity to go in one direction, the right direction, it took the opposite route and advised a different direction, which I think we all would agree now to be the wrong direction. So moving forward in terms of my experience, I'm licensed to practice law in 1979. Originally, in terms of the practice with Farm Workers Legal Services in Newton Grove, and then for, later in 1982 with the Public Defender's Office in Charlotte. And for most of my career as public defender for Orange and Chatham counties from 1990 until I retired in 2017. Most relevant to this discussion and this issue, as a Black attorney, I think my experience is probably similar to that of most Black attorneys in the state of North Carolina, where we have been subjected to and had to navigate issues of race and racism, so-called macro and micro aggressions, sometimes just blatant old-fashioned racism, more likely, more frequently, implicit bias and unwillingness or inability to perceive how race was playing out in the interactions that were taking place. I think it would be rare if you talk to a Black attorney that says, I've never had that experience before. And I think that is one reason why it's important that we do what we're talking about doing. But for me, there's something even more important or just as important. And that is when we look at the state of our criminal justice system today and the racial disparities and inequities that are so apparent, the fact that a number of Black people and other people of color have lost trust and confidence in our system because of the apparent or perceived, and I think it's a combination of both, inequities within our system. And, even if we move forward to the last several weeks, I think we are at a crisis point. And I think it's an obligation of the bar to do something to address that. And I want to, if I might, kind of loop back to Irving Carlisle, because when Irving Carlisle gave his presentation to the state bar I think his was in 1956, and I wish I had the speech here before me. I don't, but I do think it's something that both those hearings, I think, are things that I think the state bar should make more readily available. I think it's important and an important part of history, and it should be made available to the members of the bar and the public. But as I recall, Irving Carlisle said something similar to this. In moments of crisis, the members of the bar have a particular duty to help lead and engage the public in addressing the crisis, in light of their training and their special skills. And as I said, I think when I think about mass incarceration, when I think about the injustices, the racial injustices in our system today, I think we are in the midst of one of those crisis moments. And I think there is an obligation on the part of the bar to do more than some individual members have been doing up to this point. And, I think back to 2010, when I was on the board of the North Carolina Advocates for Justice. And it was apparent to me that within our state, we were not doing enough to address, the racial inequities and disparities that were, a part of our criminal justice system. I moved the North Carolina Advocates for Justice to create a task force on race and criminal justice. And in the course of making that request, I used the language, the speech of Irving Carlisle. I also used a speech that Justice Anthony Kennedy had given to the American Bar Association, I believe in 2003, which led to the formation of the Justice Anthony Kennedy Commission of the American Bar Association. And the report of that commission, I think, was released in 2004. Excuse me. And in his speech, but also in the report, there were certain, well, first of all, they clearly acknowledged the significant racial disparities and inequities in our criminal justice system and how it impacted public trust and confidence, and the deleterious impact on our democracy, and the need to do something about it. And it called upon state bars and state judiciaries to create commissions to study and analyze the how race played out within our system, and to come up with solutions to address that issue. And so the NCAJ task force was formed. Initially, Henderson Hill and I were co-chairs. Later, I co-chaired it until we were in a position to move to create the North Carolina Commission on Racial and Ethnic Disparities. And what we see today, and one of the things that we created the commission to do was to look at the data, to consider best practices, to see if we could come up with some consensus on best ways to address the issues of race and criminal justice that needed to be addressed in our system. And so when we look at where we are today, there are several things that have developed since that time. You have the ABA, recent rule, I think 8.4G, which supports the notion that bars need to be doing more. I think in 2015, the ABA LDF issued a statement related to, here again, the need for state bars and court systems to more significantly address the issues of race and justice within our systems. And one of the things that I think is most important, and one of the reasons that I think is critical that we do a mandatory CLE as a component for our lawyers in the state of North Carolina, is because this can't be perceived as just a need or a duty for the attorneys who are doing civil rights work, or those who are a part of the criminal justice system. We all are implicated, and we all are complicit when we know that we are part of a system that is flawed and we do nothing. I think so much from time to time of Sherilyn Ifill, who's the leader of the NAACP Legal Defense Fund, and how she frames this issue. And she talks about how the foundation of our democracy is flawed, and it has significant cracks and fissures, and that we need to be involved in the process of shoring up and correcting those flaws. And it can't just be a few of us. It needs to be the bar as a whole. I think it's a part of our professional obligation. And that's not going to happen unless all members of the bar are made aware of where the issues are and made aware that they can make a difference. And I think part of that can be done by having the periodic mandatory CLE component. I think there'll be a lot of support. I've had conversations with a number of people and a number of associations. And I think most people realize that this is an idea whose time has come. It's not going to go away. It's not going to get better. And I don't know that a whole lot more studies need to be done. is something that I hope and I know this is a committee of the bar, but that we can move toward getting done. I think back to the speech of the Chief Justice a few weeks ago, and I think back to the statement made by the president of this very bar, which also signaled the need to do something to address this issue that is confronting us. And I know it's not just North Carolina. I mean, it's practically all other states. But we can do something. We can do something different than the bar did in 1955 and 1956. We can move in the right direction on this instead of the wrong direction. And I hope we'll do that. Thank you.
Thank you, Mr. Williams. Peter, can you talk a little bit about the jurisdictional aspects?
Sure. I didn't know, do you want to, if anyone has any questions for Mr. Williams?
Absolutely. Absolutely. Anyone with a question? Mr. Williams, I presume you'll be willing to answer them.
Yes,
Judge,
I will.
Judge McGee?
James, tell me about the commission in terms of their interest in this possible action that might be taken by the state bar.
Well, the commission is very interested. Our board has already supported our moving forward to engage the state bar on this issue. We've set up a committee that is involved in looking at how we can facilitate this issue, this matter, progressing and maybe being adopted by the state bar. As I said, you see, our commission is very diverse in terms of membership, and we have judges, we have district and superior court judges, we have prosecutors, we have law enforcement officials, we have formerly incarcerated people, we have advocates, from various backgrounds, and so it's a very diverse group. But I think it represents practically all stakeholders and people impacted by the system, and we purposely set it up that way because we believed that in order to address the problems, the racial and ethnic problems that plague our system, we had to involve the various stakeholders and not, as I mentioned earlier, not just the civil rights attorneys, for instance, or not just the public defenders, but but everybody. And so when we look at what we think can make a difference in terms of the administration of justice in the state of North Carolina right now, we came to the conclusion that having more attorneys willing to look at what they can do to help address this matter was critical to us getting to where we hope that we can get to eventually. One of the first major programs that we did at the commission was a program, I think it was in 2014, maybe 2015, a major symposium on mass incarceration. And we invited specialists from across the country, and it was very well attended. And it was the first time in this state that issue had really been addressed in a significant way. And as a result of that, there were some questions about, well, what can ordinary, and by the term ordinary, I don't mean that to denigrate anyone, but lawyers who are not involved in the criminal justice system do to help address this issue. And so So I developed a list of about 15 different things that I sent to, in this case, it was the North Carolina Advocates for Justice, about things that any lawyer, regardless of what type of practice, they could be in oil and gas taxation, for instance. And there were things that they could do to become more engaged on this issue. So and I think it's from that standpoint that we as a commission is very interested in the notion that the state bar would impose such a requirement on members of the bar.
Thank you.
Mm-hmm.
Mr. Williams, we're the next part of the agenda is to go over an overview of what other states are doing. I would be honored if you would stay with us, but you're certainly not. You could step off if you want and watch on YouTube, or stay with us. But that's certainly up to you on whatever your time constraints are.
I'm happy to stay.
Great, wonderful.
Okay.
Just as a brief primer to before I get into the overview, there seems to be well, actually, I think now might be a good time, Brian, if you're still on, to just quickly give us an update on what is happening with the ethics committee. And so we can, before we get in an overview of statewide, just an understanding of where we are in North Carolina and other actions that the ethics committee are looking at. Is that something you could do for us, Brian?
Yeah, I'd be happy to. Good morning, everyone. For those of you that I know I've met all of you in some capacity, but I'm Brian Oaten. I'm the ethics counsel at the State Bar. Trying to live up to the role that Alice Mind has set for all of us, but but nevertheless. So the ethics committee is taking on a couple of different initiatives right now. David Allen, the chair of the ethics committee, called a special meeting of the ethics committee and invited the entire council of the State Bar to attend on Friday, if I'm getting my dates correct, June 26th. The purpose of that meeting was really not an action meeting, but it was an educational meeting. David Allen wanted to put before the ethics committee as well as the State Bar Council some proposals. One of the proposals is one that is probably familiar to a number of folks on this call, and that would be the amendment to the preamble of the Rules of Professional Conduct. For those that may remember, back in 2010, the State Bar Council approved adding a provision to the preamble of the Rules of Professional Conduct that addressed the lawyer's responsibility to not discriminate. And that amendment was approved by the council and went to the Supreme Court, but the Supreme Court declined to take action on that recommendation from the council. So David has reintroduced that, albeit with some slightly amended language that would kind of reflects one of the other developments over the course of the past 10 years, and that would be the adoption of ABA Model Rule 8.4G. So that's all to say that the amendment that David is currently proposing to the preamble of the Rules of Professional Conduct is essentially the same as that 2010 language, but just a little tweak in the language to update it. I do not have the amendment right in front of me. I'm sorry, I don't have the ability to share my screen and get that in front of me right now, but I'll be happy to send that. I don't know, Peter, did you include that in the materials by chance?
I didn't include it in the materials, but I'll send that out to the group immediately following this meeting. Yep.
Yeah. So, so that is one that David is going to be putting before the ethics committee, and again with the intention that it go before the council at the next quarterly meeting, which is scheduled for this month. July 23rd is the next ethics meeting, and the idea, I think, David is going to put that before the ethics committee. And if the ethics committee, approves that amendment, then it'd be recommended to both the executive committee and ultimately to the council of the State Bar for publication over the next quarter. The other proposals that David has submitted or introduced at this time, really two different proposals. One is studying Model Rule 8.4G. Oh, thank you, Peter. I see. Yeah, so this is, I'll pause on this next proposal. This is the language that's been proposed for an amendment to the preamble. So you see here, while employed or engaged in a professional capacity, a lawyer should not discriminate on the basis of a person's race, gender, national origin, religion, age, disability, sexual orientation, gender identity, marital status, or socioeconomic status. This responsibility of non-discrimination does not limit a lawyer's right to advocate on any issue, nor does this responsibility limit the prerogative of a lawyer to accept, decline, or withdraw from a representation in accordance with these rules. This is a provision that has been proposed for the preamble. And like I said, this is going to be before the Ethics Committee for action at its meeting on July 23rd. That's Thursday, and that's occurring starting at 9 o'clock in the morning. The other proposals that David introduced would be one, as I was saying, the study and consideration of adopting an actual rule of professional conduct similar to Model Rule 8.4G. And you can see here, there's the language for Model Rule 8.4G. This model rule was adopted by the ABA in 2016. And since, or I guess I shouldn't say since its adoption, because a number of states had actually already taken this step of adopting an actual rule of professional conduct that declares that it is professional misconduct for a lawyer to engage in conduct that is discriminatory or harassing. But the overall survey that we've conducted here is that 36 of the 51 United States jurisdictions, that's the 50 states plus the District of Columbia, 36 of those jurisdictions have adopted some form of this rule, whether it's an actual rule of professional conduct or a comment to their rules. And typically the comment comes under or is tied to Rule 8.4D, which of course says that it's professional misconduct for a lawyer to engage in conduct that's prejudicial to the administration of justice. But 25 jurisdictions have adopted an actual rule of professional conduct saying that a lawyer cannot, shall not engage in discriminatory conduct while engaged in a professional capacity. The language is not always mirroring the model rule, just to be clear. The states have, as they often do, taken the liberty to craft a rule that is most appropriate for their jurisdiction. I believe there's only 2, maybe 3 states that have adopted the model rule word for word at this point. But nevertheless, 25 states have adopted a rule, 11 states have adopted a comment to this end. So David's proposal is that this model rule and really the other versions that have been adopted by the various states out there be studied. North Carolina has never undertaken this particular study to see if we should adopt something in the body of our rules, be it the text of the rule or the comment that declares it to be professional misconduct to engage in discriminatory action. The other and last proposal that David has put forth is a study and consideration of a new comment to Rule 1.1. Rule 1.1 deals with competency. It says that a lawyer has a duty of competency, and competency encompasses a number of things, of course. Competency typically encompasses a lawyer's knowledge, skill, preparation, things of that nature. This comment that's been proposed for study would recognize that a lawyer's competency encompasses also an awareness of implicit bias, an awareness of cultural differences that could have an impact on their ability to communicate with and ultimately achieve the goals of the representation of a particular client. So this again has not been proposed for action, similar to the study of Model Rule 8.4G. Those 2 proposals have been submitted to the Ethics Committee for a study and consideration by a subcommittee that I frankly would expect David Allen to appoint at the Ethics Committee or shortly after the Ethics Committee meeting here at the end of July. So these are the I guess you call it the three different things that are before the Ethics Committee and the State Bar Council at the moment. The preamble language for actual publication for action at this July meeting, the upcoming July meeting, and then these two new proposals that are, I guess they've been presented as topics and considerations to study by a subcommittee. Thanks for pulling that up, Peter. That was very helpful.
Well, thank you, Brian. Does anyone have any questions for Brian on the process of the Ethics Committee? Okay, great. So what I'll do now is go over some what other jurisdictions are doing as it relates to mandatory CLE on either bias and diversity or elimination of bias, diversity and inclusion. It certainly has different titles and different wording in different states. This document that I'm going to share is part of the materials that I sent out. This document is from the National CLE Regulators Association, kind of consortium of all the different states that regulate CLE across the country. So I didn't create this chart myself, so I can't guarantee that it is fully accurate as of the date of this meeting. But this lets you see what states are doing as it relates to a mandatory CLE requirement for diversity, inclusion, and anti-bias. Some states have actually required mandatory CLE in this field. Some states are working on it and have a new rule that will be coming into place soon. Some states have not done anything. And then most states, I think you would see, do not require this type of course, but do allow it to be considered for credit for either their ethics portion or their general CLE, which is what North Carolina is at the moment. North Carolina does not require any diversity, inclusion, elimination of bias CLE, but we do offer that as part of the ethics credit for lawyers. You can get ethics credit for taking those courses. It is approved for ethics credit, but it is not a required separate requirement here in North Carolina. You'll see that these requirements really vary. There's a huge range of ways that this could be done, whether it is 1 hour over a certain number of years, 1 hour every year, part of an optional group of courses that must be taken within a certain time frame. It really varies across jurisdictions. I think maybe what is more useful for this group is to look at actually some of the language that jurisdictions have used. And again, this was sent out in your materials. Some states have more specific language and definitions. I think Florida's is a pretty specific one, that credit can be awarded for courses that address standards of conduct in the legal profession related to the recognition and elimination of bias. Then you have one in Illinois, their rule doesn't explain anything about the diversity and inclusion requirement. It just says you have to take an hour in diversity and inclusion, and then they created a memo that explains what those types of courses are. So there's no real definition in the rule itself. Maine requires a 1 credit hour related to harassment and discriminatory communication or conduct in the practice of law. Minnesota has a requirement about educating lawyers to identify and eliminate in the legal profession from the practice of law biases against persons of race, gender, economic status, creed, color, religion, national origin, disability, age, or sexual orientation. Missouri has a requirement that one of their 3 ethics credits must be devoted exclusively or explicitly to implicit, explicit bias, diversity, inclusion, or cultural competency. New York's as well, very similar. One to point out is Washington State actually proposed a rule change that would require a course on equity, inclusion, and the mitigation of implicit and explicit bias in the legal profession. They proposed that to the court last year, and their Supreme Court actually rejected that proposal. Washington State has they've had a couple instances in the last few years where the bar has differed with the Supreme Court on some actions, and so this was one of those actions where the Supreme Court rejected that proposal. In the ABA model rule on mandatory CLE, they define diversity and inclusion programming as programming that addresses diversity and inclusion in the legal system of all persons, regardless of race, ethnicity, religion, national origin, gender, sexual orientation, gender identity, or disabilities, and programs regarding the elimination of bias. North Carolina, the closest that we get to having anything about elimination of bias and diversity and inclusion in our rules is our definition of a professionalism program in mandatory CLE, in our CLE rules. And that is programs devoted to the identification and examination of and encouragement of adherence to non-mandatory aspirational standards of professional conduct which transcend the requirements of the rules of professional conduct. Such programs address principles of competence and dedication to the service of clients, civility, improvement of the justice system, diversity of the legal profession and clients, advancement of the rule of law, service to the community, and service to the disadvantaged and those unable to pay for legal services. I don't want to put Alice on the spot here, but I imagine we defined that program before the real appearance on the scene of courses related to elimination of bias and elimination of explicit or implicit bias, which is probably why that was not listed in that definition.
That's probably a fair statement. I know there was a point in time when we changed the definition of professionalism, precisely to encompass teaching on issues related to race and diversity and all of that, because it hadn't seemed to include that, and we wanted to make it clear that it did include that.
Great. Just going back to if you see, I mean, one thing that you notice in these rules or in these definitions is that the requirement for training on diversity and inclusion and elimination of bias is very much, and I believe every single one of these rules is specifically tied to how this is included in the legal profession and not just in general. They want the training to be specifically tied to elimination of bias and diversity and inclusion in the legal profession for these requirements for lawyers. As it relates to today's meeting, I just wanted to give that kind of jurisdictional overview and point out that depending on where this group goes, there are a lot of different options. There's a lot of language to study and use to come up with any options here in North Carolina. Some states, it's part of a 3-year requirement. Some states, it's every year. I don't think we need to talk about those plans and options at this meeting. That might be for our next meeting, but there certainly is a wide array of ways we could go with something like this. And it's clear that some states use the words diversity and inclusion, and some states focus on elimination of bias, implicit and explicit. That is another thing for this committee to discuss on how we would like to go. I think Dorothy had her hand up.
Yes, Peter, that's actually what you just stated is what I wanted to comment on about. I wanted to encourage this committee to consider with all of this. First, I want to say thank you, Mr. Williams, for that presentation. I think that was phenomenal and is well needed. This is a great time for all of this. It's past time, really, but we definitely need to seize the opportunity that we have. But I wanted to point out that when I hear diversity and inclusion, I don't automatically hear anti-discrimination and elimination of racial bias and those types of things. I know a lot of people may correlate them as all in the same, but it's not always the same. So I would encourage this committee to consider definitely including language like anti-discrimination and racial, having some training against racial bias. And, you know, we have heard a lot about racial equity training and all of those different things, which is very different than what, well, not very different. I think it's different than what we would want to look at here, specifically for the legal profession. I think that racial equity training is phenomenal, and I would encourage everyone to participate in those racial equity trainings. But I think we are on point to look at this specifically as it relates to the legal profession, including those things like diversity and inclusion and anti-discrimination and racial bias.
Thanks, Dorothy. Alice?
Yeah, it's really to follow up on what Dorothy was saying. First of all, I want to thank Mr. Williams for that excellent presentation. And while you were talking, I was thinking, wow, I want to ask him if when we have this requirement, he'll be one of the teachers. Because I thought what you said was inspiring. I thought the historical perspective was particularly important. And one of the things that you said was that really this is about access to justice and about our justice system and the role that lawyers play in that justice system, and sort of owning our responsibility for making sure that it is a system of justice and not just justice for some. And that actually, that idea that we want to, if we're going to have this requirement, let's make it something that's broad, that encompasses a lot of these ideas. It's not just narrowly focused on implicit bias or diversity and inclusion. And there's a good practical reason for that as well. And I think the conversation about the professionalism requirement was a good example. When we first wrote that requirement, and it's not a requirement, we sort of expanded the ethics requirement to include professionalism. But when we first wrote the definition of professionalism, it was pretty narrow. And what we found were there's these proposals for classes that were excellent, but didn't seem to fit under any of these rubrics, you know, general CLE or professionalism or professional responsibility. And that seems to me to be something that would be applicable here, especially if this is a recurring requirement. So we're talking about not just something for the next year or two, but we're talking about something that could last for 20 or 30 years as a requirement. And so I would encourage the committee to think broadly about this. I particularly was struck by the Oregon approach, which is, it's an access to justice credit, which includes issues related to diversity, inclusion, implicit bias, and all that, but also gets to that broader idea about our responsibility in seeing that our justice system is not discriminatory and full of bias. So just some thoughts based on my background in running the CLE program at one point in time.
Thank you, Alice. George, I'm happy to move into kind of the next agenda item if there's nothing else we want to talk about with how jurisdictions are taking a look at this.
Does anyone have any comments or questions about the language and definitions that Peter had distributed to us last week?
Chief?
I'm sorry.
Judge? Oh.
Yeah.
Judge McGee, did you have your hand raised? Okay.
Yes, I'm sorry. I didn't actually have a question, but more a comment, and that is that I think these broad definitions that I was reading through these different states were exciting to me, but they covered so many different kinds of behavior or attitudes and ways that we can help move the practice of law and the system of justice that we have in our state forward. I too appreciate the fact that we can have a broad sweep, and I certainly would be encouraged to do that.
Anyone else have comments or questions regarding the presentation so far? right, Peter?
Sure. So this next agenda item is kind of stepping back from the actual language and discussion around what a requirement might be, is to just kind of look at how this might play out time-wise and logistically here in North Carolina as it relates to our meetings, our database and technical abilities, and how a bill becomes law and all of that. So. And this kind of blends into next steps as well. So if we have another meeting, which I think this committee sounds like would be interested in having another meeting to move forward sometime in August, in early August, and maybe even another meeting after that in late August for a preparation of some sort of recommendation to the full CLE board, which meets in September. Their board retreat meets in September. Assuming this is just, let's say this is the most streamlined, best case scenario for something being done quickly. The CLE board would consider this proposal in September, potentially make a recommendation to the state bar for consideration in the October meeting of the state bar. The state bar would then, if they did not feel that there was any additional study necessary, which is certainly not always the case, they could propose an amendment for publication, which would go out for publication between October and January. It would, assuming there are no comments that require any changes, and on a topic like this, that's a pretty bold assumption. It would come back in January, potentially for adoption by the state bar, January 2021. And so that being adopted by the state bar would then be sent to the Supreme Court for approval. The Supreme Court would approve, if the Supreme Court determines that they approve this rule change, it would become effective for the 2022 CLE year. So just to keep that in mind as a setting of expectations, the fastest way this could possibly move would be to become effective for the beginning January 2022 as a requirement. That links in well with our technical capabilities at the bar, because I will admit to our current database and reconfiguring our rules would be practically impossible to have something done for the 2021 CLE year. We wouldn't be able to program that correctly in our database. So I think 2022 CLE year is a very acceptable timeline in terms of both our internal capabilities and the rule progression as how it would have to play out. It would also give us time to educate lawyers on a new requirement, which is what we did with the technology requirement, is we gave a buffer of a year to have lawyers become aware of a new CLE requirement. So that's just to set the expectations. It could certainly go slower than that. This is an important topic, and we don't want to rush it. We want to get it right. If you know the way the group goes, and so I can foresee that the CLE board as a full board may want to look at it longer. That the State Bar Council, when they receive it, might want to look at it longer. That there's potential comments and edits after it would be published. So we just need to be prepared that it could stretch. As long as it gets done by the middle of 2021, it's in theory possible to have it become effective in January of 2022. But if it stretches much longer than that, then you're looking at something becoming effective in January of 2023, because we don't add a rule requirement for CLE in the middle of a CLE year. It needs to be something that's added at the beginning of the CLE year. So that's just for all of us to think of, make sure that we're set on our expectations. Dorothy?
As you were talking, Peter, I just had a question. And this
Sure.
is down the road, I'm sure. And I know Alice, you like the guru on everything. Has there been any of these kind of requirements? Is it possible to have like a grandfathering in, like say this doesn't get in place until January of 2022, but folks have participated in this kind of training up to that point? Has there ever been any kind of, requirements like this that allow for folks to use back time And the reason why I'm asking that is because I know this is just a huge thing everywhere. I'm actually on, still on my local bar board as well. And we are working on providing this kind of training for our members, for Durham County bar members. And so I was just wondering.
So there is, when we created the requirement that lawyers have to take a class in trust account management, that although that's not part of our CLE database rules, it's just part of Rule 1.15 that lawyers have to take a trust account course if they operate a trust account. We allowed it to be grandfathered in a couple years prior, but that's not that is not coded into our CLE database. I think we would have to be concerned about it being able to track someone's apply a prior course to someone's record. Right now, we certainly wouldn't be able to competently do that, but that's something, it's always possible with new technology, but that's not something that we've been able to do with new requirement like technology, or anytime we've changed an ethics requirement. I'll leave it to more of the expert Alice to correct me.
Getting a lot of credit I don't deserve here. So Dorothy, I want to make sure I understand your question. Right now, all of those courses get CLE credit. They're getting CLE credit. They're all credit worthy under the professionalism definition. And I know I took a really liberal approach when I was reviewing requests for accreditation. I'm pretty sure Peter takes the same approach. Deborah will nod if I'm right here. So all of those are getting CLE credit. If you're looking at, being able to tell people, well, we're anticipating this is a requirement, you can take it now, I would be reluctant to encourage that, just because based on my experience, there's always these bumps along the road. And I wouldn't want people to rely on that and then we're not able to do it. That's from a database perspective, from us tracking hours and all of that, that would add a fair amount of complication to what we have to do in the database. Just to bring us back to the reality piece of this, which Peter was touching on, the CLE database is probably the most complicated database at the State Bar, because we do weird things with math. You have to take 12 hours. 2 of those have to be ethics hours. The ethics hours can be general hours, but general hours can't be ethics hours. And then every 3 years, you have to take a substance abuse requirement. And now every year, you have to take a technology requirement. And so making all of that work is very complicated. We have been looking for a better database solution. And it's really organizationally wide that we need new association software, but it needs to include the CLE. And that's a priority for me. I've told the staff that I want to prioritize that and try to get that done, because we just think that the current situation with COVID-19 means we're going to be doing remote work for a long time, and we really have to have our databases working as effectively as they can. If we can get that done this year, we will be in great shape for adding a new requirement that would be effective in 2022. If we can acquire the software we need, and that's been difficult identifying it, but get the software we need and then customize it, then we should be in good position for 2022. And we might even have the ability to do what you're saying, Dorothy, which is if somebody had taken, I want to call it an access to justice course, because I like that, but had taken that, say in 2021, that we might be able to give them credit for it. That whole issue of how credits flow backward and forward in time is one of the complications. And that's something at some point this subcommittee may need to sort of think about too. And also, is this an every year requirement, an every other year requirement, all of those things, which every one of those things adds complication to the programming. So just to keep the real world piece of it in there.
So that's that's kind of where we are practically. I do think we'll be in a place to have a new database in early early 2021, which should be able to have that configured. One of the other reasons about having one of the benefits of having a delay in a new rule is to give providers the chance to create these courses, and that's another thing this committee will have to discuss at another meeting. Is if we go the route to require these courses, we want good courses, and so the more guidance you give to providers on what these courses should be like. You want to encourage the best courses that we can have. I don't think we can have Professor Drennan go to, teach 500 courses a year and teach his bias course to everyone, even because it's so well received. But we want to do our best to limit the number of kind of poor courses that still qualify for credit. I mean, there's always courses that qualify for credit that aren't as good as others. I mean, that's just how it's going to be. But we want to try to maximize the number of good courses, and that means giving providers time to create them. And so we'll need to work on that. That puts us into next steps, George. I leave it to you.
It would seem to me that the first next step we need is to set a day for a meeting in August. The first week of August is Monday the 3rd through Friday the 7th. Would that be convenient for all the members of the committee? Judge McGee, I see you nodding. Professor Mitchell, I see you nodding. Professor Drennan, I got a thumbs up from you.
I'm not going anywhere from here to eternity, so I think I'll be here on this chair.
Well, with your permission, why don't we look at Tuesday, the 4th of August? Is this time, is 10 o'clock a convenient time for everyone, or would something earlier or later be preferable?
Just as for what it's worth, Peter and Alice, that's when our internal managers meeting is scheduled, 10 o'clock on August 4th. So I don't know if that makes a difference.
Well, we can always bump that to a different time. I think if the board here is able to be here, we'll prioritize this one. But yeah,
that's what we did today. I think Deborah sent Dixon an email just while we were meeting, just to find out, like, what happened, and we'll check in with Dixon as well and make sure that he can make the next meeting.
Then why don't we schedule that for Tuesday, the 4th of August at 10 a.m. And Peter, maybe ask that you set us up another Zoom. I don't think in the next 4 weeks we'll be in position to have an in-person meeting.
no, I don't think so. I will do that. And George, as far as for the next meeting, we'll need to just decide what the board is interested in hearing at the next meeting, whether that's proposed language, maybe a presentation on the types of courses that we would see, whatever the board's interested in, we can put together as it relates to getting materials out and setting up.
I would ask that if any of the members of the committee or any other interested people have suggestions for course composition or matters to be covered by courses, if they could send that to Peter. And Peter, I'll ask you to be the storehouse or the collector of information, please.
Sure.
And then if you can just compile that and send it out to us so we can review it maybe 4 or 5 days before the meeting.
Sure, I will do it.
Yeah. Does anyone have anything else that they think should come before the committee at this point? Yes.
I don't. I'm really pleased that this conversation is taking place. I mean, I've spent a lot of time thinking about this and teaching on at least some of these topics, and it's foundational and fundamental to a system that's fair. And what every time I teach, I ask people what's the most important value. I'm really talking about the court system, and fairness is a 98% winner. And so it has lots of dimensions. Race is a huge one, but I just wanted to echo what Alice said, which is we're in this for the long haul, and it really is it's a topic that has many dimensions. The complicating challenge for me is figuring out how to define it in a way that it both is something we continue to talk about. Unfortunately, we've been talking about race for hundreds of years, and we aren't very good at it yet. So we have a lot of work to do. But I think this is really an important thing for the bar. So I wanted to thank you all for recognizing this and taking it as a task that you think you should be doing. And if I can help in any way, let me know. But I will say I've never had any trouble getting the courses that I teach approved. So I've felt blessed in that. And in fact, James Williams and I co-teach a class occasionally, so it's always been fun to be with him too. So I just wanted to say thank you, really, and I'll be happy to help in any way I can.
Chief,
We appreciate your being with us today and look forward to working with you.
I will say I noticed that I'm the only one who has a T-shirt on.
It's a Duke t-shirt.
Yeah,
It is a Duke T-shirt
Well, I noticed.
with a Carolina mug, I will say, but we are banned from our building until September the 1st. So I've gotten into some bad habits.
Well, if you're wearing a Duke T-shirt, that is a very bad habit.
There you go. See?
My mama taught me not to use four-letter words.
I hear you. Noted.
Judge McGee.
I just wanted to say thank you, Jim. I appreciated your joining the committee. We're honored to have you. We know what your experience has been, and we know how well you do it. And encouraging others. If you get a return on a listing asking for people to give you which one of the speakers do they appreciate the most, and the speaker and the topic, Jim's always at the top of ours. And that is for law students, and that is for judges. And it's just been extremely valuable to each and every one of us. I also wanted to mention the fact that fortunately we have the CLE board has been talking about bias and diversity and the need for more emphasis on it since I think Alice, you and I and Peter were at a seminar of the Advocates for Justice, and it came up very clearly in the room that day that there was strong support for the fact that we needed to take some action or consideration, particularly when somebody asked me, okay, is not diversity more important than technology? Sure, clear focus. So I'm pleased that, we've already been able to move forward on this, and we're already discussing it. Thank you.
It looks like we might have lost George here. He timed his exit very well, though, because I think we don't have anything else left on the agenda. So we can adjourn the meeting, and I just thank everyone for being here. Mr. Williams, for your presentation. This was just a great meeting. And what I'm actually going to do is I have the access to our old State Bar minutes. I'm going to go back and see if I can find the minutes from that study from the 50s and see if we can't get some of that language sent out to everyone and posted.
That would be great. Thanks for having me.
Thank you for joining us.
Okay.
And with that, I think we're adjourned. Thank you, everyone.
Everyone.
Hey, James, take care of yourself.
I will. Thank you. You too, Jim.
Yeah, I'm worried about your cough, though.